any information or receive any information from anyone about this case or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial are...
Let's pause here, because this opening matters. 3 separate felony counts. Multiple years. And yet, not guilty across the board. That plea isn't a statement of innocence, it's a demand, prove it. And in a case like this, where allegations span childhood memories and years-long timelines, that burden is everything.
During the argument, if not supported by evidence, or statement of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt.
This is where trials get won or lost. Not in emotions, but in definitions. Continuous sexual abuse sounds straightforward, but legally, it's very specific. The jury doesn't need dates. They don't need every detail. They just need to agree that at least 2 qualifying acts happened over 30 days or more. That's a massive prosecutorial advantage.
It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors, or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and
Did you catch that? No statute of limitations. That means time is not a defense here. Decades could pass, and the case can still be brought. That cuts both ways. It protects victims who come forward late, but it also means jurors must judge memories without physical evidence. And that's where doubt either grows or collapses.
these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you are retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all
This part confuses a lot of people and the jury. They don't have to agree on what exactly happened, just that something happened at least twice. Different jurors can believe different acts, and the verdict can still be unanimous. That's legally allowed, but ethically, it's uncomfortable. Ask yourself, does that feel like certainty?
communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. All right, ladies and gentlemen, each side will have 20 minutes to present their closing arguments to you. State.
Good morning, everyone. I'm going to go up to what the judge read for you, but I want to clarify a few things. Those are specifically about pending charges against you. I'm actually going to begin with count 3, and I'm going to work my way to count 1. Okay? Count 3, as the judge read, says, if you find some evidence beyond a reasonable doubt that on or about the 5th elements of all of these counts, okay? You get elements as like a checklist, okay? You're checking up all your boxes and make sure that everything is that you have to get is there, okay? It's the same creative piece. What I just read to you, one about the continuing numbers of the first element we count for, okay? What that means is that we have to prove to you, not specifically that it's in the basis of 15, but that it occurred during the time period that this was between, which is second grade, sometimes you have first period, and 11 and 12, somewhere around there, unless you talk about that's element 1, specify the such that, check that box. Second element, in Bexar County, Texas, she testified to, several witnesses heard, verified this took place at the house on Sugar Road here in San Antonio, in Bexar County, Texas. You can check that box for elements. Next, the defendant, Alexander Rodriguez, that is element 3. At the beginning of her testimony last week, when we saw her testify, she looked up and pointed that man right there is the man that did this abuse to her. That box is checked as far as element 3. Next element, they engaged in sexual contact with Emily Rodriguez, a child younger than 7.
This is critical. The defendant stayed silent, and the law is crystal clear, you cannot hold that against him. Silence is not guilt. But here's the reality, jurors are human. The judge can instruct all day long, but once that door closes, the question becomes, can they truly ignore it?
17 years. She's 17 years old, as she testified to you today. This abuse happened between the time she was in second grade and she had her first period. That element is proven. You can check that box. By touching part of the genitals of Emily Rodriguez, she testified several times throughout these years of abuse, he would touch her vagina. That element is proven. Check that box. With the intent to arouse to gratify the sexual desire of any person. That may be a little bit more complex than the others, but I promise you it's not. Because there is no reason why anybody should touch a child in that way other than to gratify their own sexual desires. That is proven. Check that box. That count has been proven to you all on this report. Go to count 2. Now, if you find from the evidence, beyond a reasonable doubt, that first element, on about the 14th day of November 2014, exact same way that was proven to you, same count 3, check that box. Bexar County, Texas, exactly as it was in count 3, check that box. Defendant, Alexander Rodriguez, that element proven the exact same way as it was in count 3, check that box. They engage in sexual contact with a child younger than 17 years. 10 years before again, you check that box. New one is by touching the breast of Emily Rodriguez. Again, she testified several times throughout these years of abuse by the defendant. He would touch her breast and nipple area. That is proven to you. You check that box. Last element, with the intent to arouse to gratify the sexual desire. Again, there is no reason why anyone should touch a child in that way other than to gratify their own sexual desires. You check that box, that count is proven to you as well. Now, what's a little bit more complex is count 1, but it really isn't. I'm going to go through it with you again right now. Count 1. Now, if you find from evidence beyond a reasonable doubt that in Bexar County, Texas, the defendant, same way as in counts 2 and 3, you check that box, did then and there during a period that was 30 days or more in duration, to wit, from on or about the 11th day of November 2013 to the 11th day of November 2017. That's the time frame that the victim testified to you all, from the time she was in 2nd grade up until she had her first period. That element is proven to you. You check that box off. When Alexander Rodriguez was 17 years of age, he is an adult, ladies and gentlemen. He's older than 17. You check that box. Or older, commit 2 or more acts of sexual abuse. I'll get back to you guys on that one. Against Emily Rodriguez, a child younger than 14 years of age. She testified again. This happened from the time she was in 2nd grade until she had her first period, well before the age of 14. That is proven to you. You check that box. So let's get back to that element previous. Commit 2 or more acts of sexual abuse. And you all have 3 ways to decide how those 2 acts are proven. Number 1, Alexander Rodriguez did intentionally or knowingly cause the sexual organ of Alexander Rodriguez to penetrate the anus of Emily Rodriguez, a child who was younger than 14 years of age. This is her testifying to you all that he would use his penis to penetrate her anus. Okay? Number 2, Alexander Rodriguez did intentionally or knowingly cause the sexual organ of Alexander Rodriguez to contact the anus of Emily Rodriguez, a child who was younger than 14 years of age. This is her testifying to you all as well about him touching her anus with his penis. The third one, Alexander Rodriguez did intentionally or knowingly engage in sexual contact with Emily Rodriguez, a child younger than 14 years of age, by causing Emily Rodriguez to touch part of the genitals of Alexander Rodriguez with the intent to arouse or gratify the sexual desire of any person. That is her testimony, that at night, in bed, he would pull down her underwear, take his pants off, grab her hand, put it on his penis, put his hand on top of her hand, and use it to masturbate. Those are the 3 options you have. You all do not have to agree on those 3. You, sir, could think that he penetrated her anus with his penis and touched her anus with his penis. You, sir, could think that he touched her anus with his penis and he masturbated himself with her hand. You could think that he touched her anus with his penis and he penetrated her anus, and the third one as well. You could think that masturbate both times. You could think touch anus both times. You could think penetrate anus both times. It doesn't matter. So long as you all agree on at least 2 of those, that is proven. All 3 of those have actually been proven to you, and you should find him guilty on counts 1, 2, and 3. This man is supposed to be her father, her greatest protector, but unfortunately he has become the man of her nightmares. I think we'll reserve the rest of its time. Okay.
Defense.
Good morning, ladies and gentlemen of the jury. Good morning. It's been a long 2 weeks. I'll try and be as brief as possible, but we have a lot to get through. This is not a grocery checklist. This is not a task list. This is not a quiz. This is his life, and it's serious. This is the rest of his life, so we should treat it as such. We are going to ask that you find him not guilty on all counts. Can you play? Let's talk about what you did here. The investigation or lack thereof. Deputy Hyman. He never spoke to Emily. Child outcries September 15th of 2022. He goes to the home and talks to Clarissa. Who the hell is Emily? Your child just outcried of sexual abuse for the last 5 years? Why wasn't she home? Where was she? Clarissa didn't disclose the affair to that officer because of Roy. The only thing that deputy testified was that a crime may have occurred. That was his only task, to take contact information, address information from my client, so that the police had that information. My clients lived there for as long as anyone can even remember. Let's talk about Detective Trevino. If anyone needs to change careers, it's Detective Trevino. He never went to the home. He never collected not one piece of evidence. Reminder, all the exhibits that you got, 40 plus exhibits, not one from the state. Not one. They never talked to the school counselor. That's huge. This was the first adult she told about what allegedly happened. And mind you, when Emily came back and testified, she said the only reason she said something was because the counselor went to go find her. He never talked to Emily. He testified to that. Never talked to Emily. And you know why that's really important? Because Emily got on that stand and was able to be manipulated and malleable to be able to say, oh yeah, I talked to him. She did. They implanted these memories onto her, or she just straight up lied, just to be agreeable. That's terrible. That is absolutely terrible. He never reviewed the body camera footage. It just wasn't important for him. He's about to send this man to prison for the rest of his life, and he can't be bothered to review a video? He never even reviewed his own interview with Clarissa to look for inconsistencies. He never talked to the reporting officer to look for inconsistencies. He never requested CPS records. Guess who did? I did. We did. He never requested therapy notes. Guess who did? We did. He never requested medical records. Guess who did? We did. He never got school records. Guess who did? We did. He never talked to friends, family. He never talked to the teachers or principals. Some of you in here, I think, are teachers. You know which students make up big lies and which ones don't. That's huge. They know the goings on at school. They know if someone's a known liar. They know who's telling the truth and who's lying and who makes stuff up. But he couldn't be bothered to do that. They never talked to neighbors who could have heard something going on, seen something going on. Never talked to the principal. Hey, does Emily have any behavioral issues? Does she have problems with authority? Didn't matter. Doesn't matter. Never spoke to Alex's family. That is huge. These are the people that were living in the same household where this alleged abuse was going on. Why not reach out to them? He never spoke to any other potential suspects, which includes the people in the home. You know what I find very interesting? State never asked any of the witnesses, did you touch him? Did you touch Emily? Such a simple question, right? Never asked. They teach you in law school, never ask questions that you don't know the answer to. There was no eyewitnesses, no DNA, no stain exam, and he testified, yeah, victims sometimes lie. He never collected Emily's cell phone. When Emily testified, she said, yeah, we had a really good relationship. She recognized her dad's cell phone from years ago. That's his cell phone. And yeah, we called each other bro, we called each other shorty. We had a great relationship. I wanted to spend more time with him. That is absurd. That is absolutely absurd. Someone has anally raped you for 5 years, every single visit, and you want to spend more time. Doesn't make sense. He never collected Clarissa's cell phone. If he had, he would have found thousands and thousands of sexually explicit material from Clarissa sent to Alex during the middle of her marriage. He never looked for custody orders. You saw the petition that was introduced. It was there. He just took Clarissa's word for it that there was no paperwork on it. Let's talk about Clarissa. She asked Emily to keep secrets for her benefit so that she could continue this affair over the course of 4 to 5 years. She testified she couldn't remember her weekly sexual visits with Alex. You heard from multiple members of the household she'd come by every week for their rendezvous, with or without Emily. However, she also testified she would send sexually explicit photographs to him. However, she could not remember the purling. That doesn't make any sense. She didn't say, I'm not denying that he has those purling. I just don't remember. That doesn't make sense. You know that. I know that. Everyone here knows that. She testified they had the affair from 2014 to 2017. She also testified, yeah, I asked for money. Your daughter has alleged she was anally penetrated for years, and you don't care. I'll take your money. You still owe me. Give me the money. Even after he was arrested, she's still asking for money. She would send Alex updates about how she's doing. Oh, she's doing great in the orchestra. What? She goes to this school now. This is the man who raped your child, and I'm going to give you an update as to how she's doing. She misses you. She's wonderful. She's doing really great in school. That doesn't make any sense. She didn't believe that she was actually raped. It doesn't make sense. She told Alex about the abuse that she was suffering at the hands of Roy.
And there it is, the emotional anchor. This man was supposed to be her protector. That line isn't about evidence. It's about identity. About betrayal. About who the jury wants to believe deserves protection. From here on out, this case stops being purely legal and becomes deeply human.
Her husband. Not just Emily, but the other kids as well. Thousands of sexual communications between the two. Thousands. And she claims that her mom faked those 2 CPS challenges and requested monthly rape kits for Emily. This was before the outcry. Someone asked for monthly rape kits of Emily. And Clarissa says it was probably my mom. She's crazy. Well, the apple doesn't fall far from the tree. Eric Mata. He denied that Emily ever mentioned camping. It happened on the same day, on the same days, same time, same place. Nothing about camping. Then when she testified in front of you the first time, She didn't mention camping. Then when we brought her back, oh yeah, it happened when we were camping and there was other family around and there was other campgoers, but he still did those things to me. It doesn't make any sense. It does not make sense. Eric said that she yelped at the pain of penetration. I don't know what the answer is here. She testified in front of you that there was no penetration. She wasn't sure. How can you convict somebody who doesn't even know if something happened or not? How can you put him in prison if you don't know? He never asked if she was sexually active or knew what a penis looked like. He never asked if she was forced to be in the room telling her story. He says that that Alex tried to kiss her. She never told you guys that. She never told the DA's office that. She never told CPS that. She never told the counselor that. She never told her mom that. Emily didn't mention showering afterwards. Imagine a 6-year-old child who's been anally penetrated for years, getting up, taking a shower, and staying in the bathroom for hours. Never mentioned that. Not to him. Roy Herrera, where is he? He was subpoenaed. Clarissa confirmed he was subpoenaed for us. We wanted to hear from him. We wanted to see what kind of influence he had over Emily, but he was stubborn and didn't want to be questioned. School counselor, where is she? She was the first adult that talked to her. Where is she? The timeline. We know the pearling procedure happened in 2011. 2014, Alex moves in with his mother and the visits start happening. Alex, Christina, and Ethan are living together. She was 7. Then in 2015, Alex and Clarissa begin their affair. Again, Alex, Christina, Ethan are all living together. Then 2016, the affair continues. Alex, Clarissa, Ethan are living together. Emily is 9. 2017, I put down here, Emily gets her period. Who knows? She has no idea whether it's 2017, 2018, 2019. But somewhere in there, she's living with Alex, John Paul, and Ethan. And we know the affair keeps happening because John Paul and Ethan both testified Marissa's coming by weekly. 2020, Alex and Clarissa end their relationship, and things spiral. He meets Lisette and starts dating her, and he's still living with Alex, John Paul, and Ethan. This was when Emily's 13. 2021, Clarissa starts asking for money. They're not dating anymore, so she wants her money. She's not getting those dates anymore. She wants her money. Lisette moves in with the kids. Emily allegedly commits or tries to commit suicide. Alex, Lisette, and the kids all move in together. And she doesn't want to share a room. She doesn't want to be there. She is starting to pull away. 2022, Emily starts sneaking out, and somebody files and asks for monthly rape kits of Emily with CPS. Then 3 months later, here comes the outcry. Alex, Lisette, and the kids. CPS interviews the kids. No outcries. No outcries of abuse. And they leave the kids with Alex. Little kids. No one believes this. After the outcry, guess who's still messaging Lisette and Alex? Emily. She misses them. She wants to talk to them. She wants to see how they're doing. She gives them updates about herself and her mother. And what I find the strangest about all of this, Clarissa moves to Houston with Roy and the other kids and leaves Emily. Who does that? You have a man who is her father, who has legal custody of her, right? And you move to another city without her, without any protection whatsoever. He hasn't been arrested at that point. How protective is she as a mother? She knew this isn't true. She knows this was not true. Again, Alex, Lisette, and the kids continue to be together. In 2023, in January of 2023, the detective turns the case into the district attorney's office.
5 minutes.
Thank you, Judge. Clarissa continues in 2024 to message Lisette and Alex. Alex is arrested. Then Emily's still going on vacation with his family. None of that makes any sense. None of it. And guess who's still asking for money? Clarissa. We talked about when is it too late to walk a lie back. Emily stated, I asked, do you think you're going to get in trouble if you say you made all of this up? And she says yes. Winston Churchill said, a lie gets halfway around the world before the truth has a chance to put on his pants. The DA's office sat on this case for 1.5 years. That disadvantages us.
It's a proper argument, Judge.
Sustained.
Common sense. They have the burden of proof. You can find somebody guilty based on the testimony of one witness, but that one witness has to be credible, and Emily is not credible. Remember the standard of proof. They have to prove every element beyond a reasonable doubt. And remember, to terminate your rights as a parent, it has to be clear and convincing. If it's not enough to terminate your rights as a parent, which obviously it wasn't for his rights were never terminated, then it's not enough evidence to take his freedom for the rest of his life. The inconsistencies. Emily said it was every other weekend in the same room, same time and place, and then years later she says, oh, actually, we were camping. She claimed she felt something wet on her back, and then